Hi, welcome back to my channel. Please like, comment, and subscribe. A maritime injury applies to workers who are hurt while aboard a vessel, offshore, platform, or at a dock. Unlike other workers hurt on the job, maritime workers are not eligible for workers' compensation. If you have been injured in a maritime accident and are considering filing a maritime injury claim, you have come to the right place to better understand your options. Maritime injury cases can be complicated and are quite different from the typical car accident injury claim both in terms of complexity and the potential benefits. Types of maritime injury claims. In general, there are several types of personal injury claims you can file if you are a vessel worker or a seaman and you get injured while at work. Jones Act claim, maintenance and cure claim, unseaworthiness claim, negligence claim, Jones Act claim. The first one is the Jones Act claim. It is stated that the federal government passed that protects injured maritime workers. This kind of claim can only be filed by maritime workers who are classified as a seaman, which is essentially someone who spends 30% or more of their time on a vessel in navigable waters. Unlike workers' compensation, Jones Act claims are filed directly against the employer of the plaintiff. Maintenance and cure claims. The second claim is what they call a maintenance and cure claim. So that is actually a general maritime law claim, but they call it maintenance and cure, which basically covers your medical expenses and some money to live on. By law, employers of injured maritime workers are required to pay for your medical treatment up to a certain point, as well as your living expenses while you recover. If they refuse to pay you the full amount, then a maritime lawyer can file a maintenance and cure claim to force the company to pay your damages. Unseaworthiness claim. Maritime employers are required by law to provide safe workspace and seaworthy vessels. If they do not provide a safe workspace or the vessel is unseaworthy and someone is injured, that is a liability and grounds for an unseaworthiness claim. This claim also falls under maritime law. You can file an unseaworthiness claim and seek any damages you suffered due to the unsafe equipment or vessel. Proving unseaworthiness can be difficult at times, but with the right evidence and documents, we are able to show how employers could have provided a safer workspace. Negligence claim. It is another claim you can file is called a negligence claim. A negligence claim basically means that you are demanding on someone else repay you for damages that they caused through their careless or reckless actions. If the company failed to follow safety rules, then they are considered negligent. If you have a slip and fall on the slippery boat deck, then your employer is potentially at fault for not providing non-skid surfaces or taking other precautions. Under a maritime law negligence claim, you can recover any damages you suffered, such as pain and suffering, wages loss, medical costs, or any other harms. It is not always a simple matter of proving your negligence claim, so we offer these 5 tips for proving negligence after an injury. In many of our cases, our client will have claim under the Jones Act against their employers. And at the same time, they have maritime law negligence claim against any responsible third parties who may have also contributed to their accident. You may have been working for your company, but on a vessel owned by another company, or you may have been working with other company employees who contributed to your accident. It is not uncommon for us to file Jones Act and maintenance and cure claims against an employer. Maritime negligence claims against a non-employer, and even an unseaworthiness claim against yet another party that owned the rig or vessel. While this may sound complicated, all the claims are in one filing, and by naming all the required parties under the proper maritime laws, you will maximize your recovery. If you were injured while working on or near the water, then you may be entitled to file a claim under General Maritime Law, the Jones Act, the Longshore and Harbor Workers Act, or the Death on the High Seas Act. You have the right to pursue a lawsuit and recover damages, which is where an experienced law firm like the Young firm can dramatically improve your chance of success. Who does maritime and admiralty law apply to? Well, generally, the following people can file maritime injury claims such as Jones Act seamen, maritime workers, deckhands, longshoremen, harbor workers, oil rig workers, tugboat workers, barge workers, and other works in the Gulf of Mexico workers on the Mississippi River. You also may be able to file a maritime claim if you have been injured while working on any of the following: an oil rig, drill ship, construction barge, floating crane barge, cargo ship, towboat, crew vessel tanker, tugboat, supply vessel, fishing vessel, other floating vessel or structure. What financial compensation can I receive in maritime injury lawsuit? It is depending on your situation. You may receive compensation for your medical bills, pain, and suffering lost wages, including overtime, physical disability, mental anguish, disfigurement, loss of enjoyment of life, loss of companionship, mental disability, property damage, and loss of fringe benefits. So, our personal injury lawyers have represented clients in Louisiana, Mississippi, Alabama, Arkansas, and Texas, as well as workers injured in the Gulf of Mexico and Mississippi River. In addition, we have helped injured seamen across the United States by working with their local attorneys to ensure they have a skilled and experienced maritime injury legal team on their side. We have been representing injured maritime workers for more than 50 years, and we believe there is no blacklist. In fact, there are laws that prevent your former employer from revealing information like injuries you may have received while on the job. In addition, we have had several former clients who received excellent settlements later returned to work offshore after they recovered from their injuries. Be careful who you trust. As word gets around that you have suffered an injury, you are likely to get plenty of advice from others. Your uncle might tell you how his friend sued the oil company he worked for and got a multi-million-dollar settlement. Or the company may tell you not to seek medical care from anyone but their specialist. With all of this conflicting injury advice coming at you at once, it can be difficult to decide to whom you should listen, if anyone, for help on how to handle a maritime injury claim. Thank you so much for watching. Don't forget to like, comment, and subscribe.